Hello viewers, my name is Richard Land. I'm a Connecticut-based attorney and a member of Chipman, Mizuko, Emerson, a Danbury, Connecticut law firm. As an attorney, I devote almost all of my practice to estate planning and estate settlement. The purpose of this video is to give you a complete understanding of the basics of estate planning. Although estate planning includes the preparation of wills, it should involve much more. It's a process which includes taking into account all your resources, all the property that will pass to your survivors at your death. It should include an analysis of costs associated with the settlement of your estate, including taxes, a thoughtful selection of the individuals who should be chosen to settle your estate, and careful consideration of the special needs of your beneficiaries. There's lots of opportunity for mistakes. I've organized my comments to include a short discussion of what a will is and why something which sounds so simple can end up being so complicated. This includes a discussion of the distinction between probate and non-probate property. The discussion also will include tax considerations, what your estate is made up of, and other personal considerations. Then there will be a short discussion of problems with will substitutes and avoiding probate. That's when we'll be talking a little bit about revocable living trusts. After that, we'll be devoting some time to the basics of planning gifts. A will is merely a letter of instructions that the courts will enforce regarding the disposition of your property after your death. And let me emphasize that a will is effective only at death. There are very few limitations on what you can do in your will. You can appoint a person or a bank responsible for carrying out your instructions. That's the executor and trustees. You can appoint a person who receives property on behalf of a minor beneficiary. That would be the guardian. And you can place restrictions on how property should be used. That sounds simple. All you need to do is decide who has to receive your property, what you have, and who to appoint to make certain that your instructions are carried out. But it's not so easy because there are many things, some very complicated, which have an impact on the way your will works. In order to plan properly, you must determine which assets the will controls. This means that we have to review all your assets which are going to be available to pass to someone else at the time of your death. Then we have to figure out which assets are probate assets and which are non-probate assets. The probate assets are the assets which the will controls. Probate assets are the assets that are in your name and that are not disposed of at your death by contractual provisions. The best example of a non-probate asset is a life insurance policy with a beneficiary designation. The disposition of the life insurance death benefit often is controlled by a beneficiary designation. That's what I mean by disposition that's controlled contractually. It's part of your contract with the insurance company. Probate assets are the assets that you own in your sole name and which are not controlled by some other beneficiary designation or term of a contract. In this slide, under the title Non-Probate Property, you see examples of non-probate property. That's the property that's not controlled by your will. And you see the types of property that are typically controlled by beneficiary designation, such as life insurance and retirement plan accounts like IRAs, and certain types of trust accounts. You might have had some exposure to trust accounts if you went to the bank and you set up an account that's in trust for some other person. That means that the property in that account at your death will pass to the person who you name as the beneficiary. Jointly owned property is the property that you own with someone with rights of survivorship. Many of you, especially those of you who are married, may own your home jointly with right of survivorship. That means when one of the owners dies, the surviving owner automatically takes title to the whole property and receives the portion that the deceased owner had at the time of his death, automatically through the terms of the deed. Then there are revocable living trusts, which we'll talk about a little later. The terms of the trust agreement will provide that the trust property passes to certain beneficiaries at the time of the death of the person who set up the trust, who we usually call the grantor of the trust. So when the grantor of the trust passes away, the terms of the trust agreement will say who receives the trust property. On the other hand, if you look under the column entitled Probate Property, and keep in mind that's the property that's controlled by your will, you see that it includes assets that are owned just in your name, or it can be a certain type of joint ownership called tenants in common. If you own your real estate as tenants in common, for example, the deed will just say that A and B have the title. It doesn't indicate that there's a survivorship feature. If that's all the deed says, that Mr. A and Mr. B own the property, that means that when Mr. A dies, his half will pass according to the terms of his will. So, if in the deed you don't see some language that refers to survivorship or joint ownership with right of survivorship, that means ownership is probably as tenants in common, and when one of the owners passes away, the portion that's owned by the deceased owner will pass according to the terms of the deceased owner's will. The distinction between probate property and non-probate property is at the core of all estate planning, and estate planning cannot be done effectively unless we pay attention to those two different types of property. So, when we do estate planning, we should be spending quite a bit of time going through the assets and determining what you have and how you own it, so we can figure out what the will control and what it won't control.